Hello, everybody, and I am delighted. I'm Jillian Lester, Dean of Columbia Law School, and I'm delighted to welcome you all to the 2020 Stone Moot Court Finals. It goes without saying that this has been an interesting spring. As you know, beginning in early March, we began to cancel or postpone events, eventually packing up and leaving the building. And as spring activities began to shut down, it was interesting to observe that there was one of the groups that really remained resolute that the show would go on was our moot court finalists and organizers. I think it's fair to say that this attitude fully reflects the sort of grit and dedication that always undergirds the appearance of ease, clarity, and polish that rests behind the very, very best written and oral advocacy. I'm confident that that sort of character will be on full display in today's final arguments. I'd like to thank some of those whose hard work helped to get us to this point. In addition to the oral advocates and brief writers who you will be getting to know in today's event, I'd like to acknowledge Emily Gary, the student director of this year's Stone program, and Ryan Palladian, the executive editor of the Moot Court program. Among our faculty and administrators, let me thank Eileen Strauss, the director of our legal writing and moot court programs on year in, year out, and Dan Richmond, this year's faculty co-director of the Stone program, as well as several faculty who assisted Emily Gary in developing this year's problem: Liz Emmons, Emily Benfer, Kristen Underhill, and Philip Genty. I'll just take a moment longer. You will look forward to meeting the advocates momentarily, but I'll just take a moment longer to introduce our judges with warm thanks for their participation. Judge Joseph Bianco of the Second Circuit. He was appointed as a circuit judge to the Second Circuit by President Trump on May 13th, 2019, and began service almost a year ago this next week. Prior to his appointment as a circuit judge, Judge Bianco served as a district court judge in the Eastern District of New York. I can't fail to mention that he received his law degree in 1991 from Columbia Law School, where he was a Kent Scholar and a member of the Law Review. Before he became a judge, Judge Bianco had service both, had professional practice both in private practice as in New York City, as well as in the U.S. Attorney's Office. And he's done a bunch of teaching over the years as well at Fordham, Hofstra, Toro, and St. John's. Judge Jordan, 11th Circuit, currently serves as a U.S. Court of Appeals judge for having been appointed by President Barack Obama and sworn in early in 2012. He similarly had tours of duty both in private practice as well as in the U.S. Attorney's Office, and is a Miami graduate, and also for many years taught as an adjunct at the University of Miami. Judge Deborah Livingston in the Second Circuit has served since 2007. Prior to her appointment, she had served as a U.S. attorney. There's a theme here, as well as in private practice. But she, after years of practice, was actually became a law professor, and before moving to the Second Circuit was on our faculty here at Columbia Law School, where she was Paul Kellner professor and vice dean, and we wouldn't let her go. So when she went on to become a circuit judge, we kept her on our faculty, and she currently teaches civil procedure on a criminal procedure, pardon me, on a regular basis, and she's. We're grateful to all three judges for being here today as we launch into our competition. So again, thank you everybody for being here. Thank you for all who've made this happen. And now we have to look forward to meeting our mooters.
The Honorable Judges of the United States Court of Appeals for the Fourth Circuit. Oyez, oyez, oyez. The United States Court of Appeals for the Fourth Circuit is now in session. All having business before the court draw nigh. Give your attendance and you shall be heard.
Good afternoon. We're here to hear argument in Chen et al. Versus Secret Saturdays, case number 19-1234. Are counsel ready to proceed?
Yes, Your Honor. Your Honors, may it please the court. My name is Gregory Bernstein, and along with my co-counsel Andrew Kanarian, I represent defendant appellee Secret Saturdays. I'd like to reserve 2 minutes for rebuttal. This case presents two jurisdictional issues, those of mootness and standing. Both of these issues go to the very power of this court or any other federal court to entertain the case. As the Supreme Court has long recognized, these doctrines, which are rooted in our constitutional system of separation of powers, serve to identify those disputes which are appropriately resolved through the judicial process. This case is not such a dispute, because the court below erred both when it concluded that this case was not moot and that the plaintiffs had standing. This court should reverse. I'll turn first to the issue of mootness, which this court reviews de novo. It's well established that a case becomes moot if subsequent events make it absolutely clear that the allegedly wrongful behavior cannot reasonably be expected to recur. And it's important to note at the outset that while defendants bear the burden of proving mootness, the required showing is that of not reasonably expected. Thus, if it's possible or even plausible that the offending conduct could recur, this case can still be moot if there's not a reasonable expectation of that happening. And
isn't this case, Mr. Bernstein, isn't this case a little bit different in the sense that the mootness didn't arise out of the passage of time, but conduct that your client undertook after the lawsuit was filed?
Yes, Your Honor, but the voluntary cessation of allegedly unlawful conduct can still moot a case in this circuit if it's not likely for that conduct to be resumed. That was this court's holding in Pashby v. Elia. And in this case, the considerable changes Secret Saturdays has made have not only removed the accessibility barriers that were on their website, but have eliminated any reasonable expectation that they might arise again in the future. And those
But your client didn't create the alternative website when Ms. Chen first contacted Secret Saturdays and told them that the website was inaccessible. They didn't do so when Mr. Ross offered to sit down. This was all conduct that your client undertook after the lawsuit had commenced. Doesn't that make a difference to what station can count to render this case moot?
Yes, Your Honor. In Felton v. Pro Football, this court recognized that the timing of the changes is relevant insofar and it sheds light on the defendant's motivation and whether those changes were motivated by a genuine change of heart. And in this instance, there is a very reasonable explanation for the timing of the changes, and that's that Mr. Stewart wasn't fully aware of the accessibility issues prior to the start of litigation. So take, for instance, Your Honor, the email from Ms. Chen that you mentioned. That email, like all of the other emails that went to Secret Saturdays at the time, was received by a social media intern who failed to pass it on to Mr. Stewart. And that's why in removing the barriers, Secret Saturdays didn't simply redesign their website, but they also adopted an ADA policy, placed Ms. Antonucci, a senior official at the company, in charge of ensuring that the website remains accessible, and incorporated regular accessibility checks into the publishing workflow. And that's important.
Mr. Bernstein, that all happened after the lawsuit was filed. So under the Feldman factors, that cuts against you, right? All of that happened after the lawsuit was filed.
Yes, all of these changes began after the litigation was initiated, but it shows that Secret Saturdays took these additional affirmative steps, and it helps explain not only the timing of the changes, that the Secret Saturdays just didn't fully understand the depth of these issues, but it also goes to show how this type of issue can't fall through the cracks again, or there's no reasonable expectation of that happening. And
let me ask you about that, because I think that's the most important factor as it relates to mootness, is how much money it's going to cost to upkeep this new computer system that your client has installed. What would prevent them from deciding it's too expensive, I'm firing Ms. Antonucci, and I'm not going to continue to comply because of the cost. It has to be absolutely clear under lay law that that's not going to happen. So how can we make that conclusion here?
Well, the considerable changes means that in order to resume the offending conduct, Secret Saturdays would have to cancel third-party vendor contracts, would have to change their publishing workflow, would have to violate, the ADA policy that they've promulgated. And truthfully, there will always be some possibility that a company can decide it's cheaper to violate the law and flout anti-discrimination law. The question is whether that's reasonably likely to recur. And the Eighth Circuit recognized recently in Hillshine v. Holiday Station Store that there's no reason to believe that a defendant will spend considerable time and money in order to remove barriers, only to change them back once the litigation is over. And while this court has not held that websites are covered by the ADA, courts in the circuits that have reached that conclusion have held that ADA cases involving websites are subject to the same mootness standard as their physical counterparts. In other words, it doesn't matter that Secret Saturdays will be adding additional web pages because these cases can still be mooted. And I'd like to next turn to the issue of—
Can you answer one more question on the mootness issue?
Absolutely.
How or to what extent do we weigh the fact that it took Ms. Antonucci over a year to turn to the task that was assigned to her?
Yes, Your Honor, that doesn't deserve considerable weight. In Feldman, this court articulated two primary factors when determining whether the removal of barriers will moot a case. And those factors were whether there's a separate live dispute and the ease with which those changes could be undone. And in this case, Secret Saturdays didn't simply set out to ensure that their website was accessible to individuals with hearing impairments, but it also removed barriers that could affect someone with a visual impairment. So there's no separate live dispute, and there'd be considerable effort would have to be undertaken in order to remove those changes. And the next issue
Isn't there a live dispute about whether the accessible website that you've now created is adequate, is necessary and effective?
Yes, Your Honor, and those were the grounds on which the court below decided the question of mootness, whether the website and the portions of that website constituted a separate benefit. Yet that decision was premised on an artificial distinction between the accessible page and the home page. And despite this distinction, which plaintiffs have attempted to draw out, there's but a single website, and as all parties have stipulated to, all of the information included anywhere on that website is included in an accessible format on the accessible page. And one helpful analogy is a brick and mortar store that has an inaccessible storefront because there's a set of stairs. Under DOJ regulations, that store can become ADA compliant by removing the stairs and installing a ramp, or by leaving the stairs and installing a ramp in addition to those stairs. And that's essentially what Secret Saturdays has done. To add more color to that argument, the 10th Circuit recently considered a very similar case to the present one. In Colorado Cross Disability Coalition versus Abercrombie, the 10th Circuit considered a case in which a retailer built storefronts that were inaccessible to persons in wheelchairs and then created separate entrances for individuals with disabilities. In that case, the 10th Circuit found that this didn't constitute a separate benefit, even though a majority of patrons used the inaccessible entrance, and even though the accessible entrance lacked the same attention to detail as the main entrance. And those are very analogous to the arguments that the plaintiffs have alleged, that a majority of patrons will use the homepage and that there's some intangible aesthetic difference between the homepage and the accessible page. Yet that's
Doesn't that confuse mootness with the merits?
No, Your Honor. So that goes to the legal question of what constitutes a separate benefit. And neither this court nor any other circuit court has held that that the creation of a specially designed accessible web page is an impermissible means of securing compliance with the ADA as a strictly legal matter.
But that point is a legal point, a merits point, not a mootness point. To decide that very issue you're discussing, you'd have to presume or decide that there is a justiciable controversy, no?
I don't believe so, Your Honor. I don't believe there's a genuine issue of material fact as to whether whether the accessibility barriers have been remedied and whether the website is compliant with the ADA and its prohibition against separate benefits. The
Mr.
next
Bernstein, they cite these cases, Hooters, Woo, Sullivan, where numerous lower courts have said that website changes aren't permanent enough to make a case moot. Are those cases wrong, or are they distinguishable?
They are distinguishable. So some of the cases that the plaintiffs cite are National Federation of the Blind versus Target, but Brook versus A Ventures. But in the first case, the defendant's modifications only addressed some of the plaintiff's accessibility claims. Thus, under this court's decision in Feldman, that case wouldn't be moot for that separate reason, not because it's a website. Similarly, in Brook versus A Ventures, one of the cases cited by plaintiffs concerning websites, the district court stated that a change to a website is akin to a change in policy. Yet in 2017, this court held in Grutzmacher versus Howard County that a change in policy can be sufficient to moot a case. I think a much more on-point case is the Southern District of New York's decision in Diaz v. Kroger, where they explicitly rejected the argument that there's two different set of standards for mootness, one for physical buildings and one for digital spaces. The next issue that I'd like to address is that of standing. And because the court below erred when it concluded that the plaintiffs had standing, this court should reverse. In order to have standing, a plaintiff must have suffered a concrete and particularized injury. That injury must be fairly traceable to the action of the defendant, and it must be likely that the injury will be redressed by a favorable decision. And when a plaintiff seeks injunctive relief, as the plaintiffs in this case have done, there's an additional requirement of a real or immediate threat that the party will suffer an injury in the future. And in order to satisfy Article 3, that threatened future injury must be certainly impending. If a plaintiff can't meet any one of these four threshold requirements, she lacks standing and her claim must be dismissed. This issue is reviewed de novo. I'd like to first turn to Ms. Gomez. And Ms. Gomez lacks standing because she did not suffer a concrete and particularized injury in fact. By her own admission—
This case proceeds if any one of the plaintiffs has a standing, right?
Yes, Your Honor.
So could I draw your attention to Ms. Chen, because it's difficult for me to see how it could be the case that she doesn't have standing. She wanted to sign up for the mailing list and attend a dinner. She tried to do so and couldn't. And as for the future, she says she continues to visit the Washington, D.C. area and would like to attend a Saturday night, Secret Saturdays dinner in the future. Why isn't that enough?
So that's not enough for two reasons. And the first is that she hasn't satisfied the intent to return analysis that this court applies when looking towards future injury. And so in Daniels v. Arcade, this court refused to adopt an inflexible test, but pointed to factors such as the proximity between plaintiff's residence and defendant's business, the frequency of plaintiff's travel near defendant, the plaintiff's past patronage of the defendant's business, and the—
Can I just ask, I was a little confused by the briefing in this case. Is the injury that does the injury have to be the inability to attend a dinner, or is there an injury by experiencing the inaccessible website?
In regards, Your Honor, in regards to the intent to return analysis, is that what you're asking about?
In regards to standing, I mean, could Ms. Chen say, I may live in Hawaii, but I have access to the website, and to the extent that it continues to be inaccessible, I'm injured when I try to access it?
Yes and no, Your Honor. So a plaintiff can suffer an injury in fact when they encounter an accessibility barrier on the website, if we're to assume that the ADA applies to websites. But in regards to the intent to return analysis that's relevant for Ms. Chen, this court hasn't addressed that issue squarely, but district courts within the circuit have routinely held that in ADA cases where the only alleged inaccessibility is on the website, the intent to return analysis is still applied to the physical place of public accommodation. And that's what the court said.
What about a person who cannot physically get to the brick and mortar store? What do you do when you have a person who is bedridden, needs to shut the computer, and is surfing around to find the best prices for, let's say, home products? What do you do with that person?
With that person, it'd be a bit different because there's not a physical place of accommodation where they're trying to go to. That would, in terms of e-retail, the same intent to return analysis wouldn't apply because there is no place of physical accommodation. that.
Well, there is. It's just that the person can't get there because of his own or her own physical limitations. So with regards to that person, and to follow up on Judge Livingston's question, where is the injury? Is the injury the failure or the inability to access the website? Or is the injury the inability to get to the brick and mortar store to see the products that are listed on the website?
Absolutely, Your Honor. So the injury, in fact, can occur as long as we assume the ADA applies to websites on the website. If you encounter an accessibility barrier on the website, then assuming that there's no other issue that might make that not a concrete injury, then that can be the site of the injury. But in regards to the intent to return analysis, in these cases where injunctive relief is sought, that's applied to the physical place of the business. And that's necessary so that an individual who lives in Florida can't simply go to the websites of dozens of restaurants in Alaska, find accessibility issues, and then even though they have no intent to go to any one of those restaurants, bring suit against all of it. That would
Mr. Bernstein, even if that's correct, I want you to focus on Ms. Gomez, because even if it's plausible return to the physical location, she lives in Maryland, she attended physically one of the dinners, she signed up for the mailing list, and it was only when she was told that she could not get closed captioning on the website that she removed herself from the website. So what more could she have done? She went to an event. She said in her declaration, I'm prepared to go to another event. If they fix this, I'll rejoin the mailing list immediately. So why wouldn't she have standing?
Yes, Your Honor. And Ms. Gomez lacks standing because she didn't encounter any accessibility barrier. And while the ADA does protect against dignitary harms, this court just last year in Griffin held that not all dignitary harms are sufficiently concrete to serve as injuries in fact. And citing
No, but that's pretty concrete. Suppose I made a reservation at a restaurant. I'm about to leave and I find out I'm in a wheelchair. I find out they don't have a ramp. You're telling me I have to go to the restaurant in order to have standing, that I can't say it's going to be futile? I'm not going to go to the restaurant. I've just been told they don't have a ramp. Isn't this the same thing?
Not exactly, Your Honor. So an individual, a plaintiff, must be personally subject to the discrimination, and that comes in the form of encountering barriers. And no court, no circuit court at least, has held that merely learning about an accessibility barrier rather than encountering one is sufficient to confer standing. Only the 8th and 9th circuits have reached a conclusion even close to that, and that was, they held that an individual who encounters one barrier will have standing to challenge other barriers at the same physical location, affecting their specific disability. But Ms. Gomez—
What about the 9th Circuit case in Pickern?
The 9th Circuit case in Pickern isn't on point here. And so in Duran versus 711, a case that I believe was decided after Pickern in the 9th Circuit, the court held that a plaintiff who encounters a barrier, and both the plaintiffs in Pickern and Duran, I believe, did encounter one barrier and learn about others, could have standing to challenge, or did have standing to challenge barriers that their experts informed them about, but that was only because they themselves had encountered at least one barrier. In other words, if Ms. Gomez had seen one uncaptioned video on the Secret Saturdays website, we wouldn't take the position that she has to watch every uncaptioned video that she wants to challenge in order to have standing to bring that suit. And it looks like my time has elapsed. Thank you, Your Honors.
Thank you very much, Mr. Bernstein.
Good afternoon, Your Honors, and may it please the court. My name is Christen Hammock, and I represent the plaintiffs in this case alongside my colleague, Lydia Turnage. This case is about ensuring that disabled Americans can vindicate their rights to goods and services under the ADA, even when those services are partially provided online. I'll be addressing standing and mootness. First, plaintiffs have standing in this case because they've demonstrated a concrete and personal injury that's causally linked to Secret Saturdays' inaccessible website. Second, this case is not moot because Secret Saturdays hasn't met their heavy burden to prove that the harm at issue here won't resume as soon as this litigation is over. For these reasons, this court should affirm the district court's proper ruling that this case is justiciable. So following my opposing counsel's lead, I'll start with mootness. This case is not moot because defendants have argued that their own voluntary cessation of the offending conduct in this case is something that renders the case moot. They've taken on a heavy and formidable burden to prove that as soon as this litigation is dismissed, they won't just resume the contact all over again. So the plaintiffs in this case are arguing that they have not met the voluntary cessation doctrine on 2 points. First, as Mr. Bernstein said, they have to prove that it's reasonably certain that the conduct won't recur. And this is an evidentiary burden. So it's not enough for defendants to merely say, we promise that this harm won't recur if this litigation gets dismissed. They actually have to provide evidence that it is absolutely clear that it's not reasonably likely for it to recur. So in this case, defendants have not offered sufficient evidence to prove that that's
Well,
true.
hasn't Secret Saturdays now publicly adopted a new ADA compliance policy, and its website has been approved by a third-party vendor as compliant with the guidelines? I mean, if it were to back off that new policy now, it would be very publicly retreating from an affirmation that it intends to comply with the ADA going forward. How likely is a company to do something like that?
Your Honor, I think it's certainly likely. And I think that this case is distinguishable from other cases that have either found that a policy is sufficient to moot a case or found that things like changes to a website are also sufficient to moot a case. So
here we
first,
have both, right? We have significant
Yes, Your Honor.
changes to the website and policy changes and public policy changes.
Certainly, Your Honor. We totally agree that there have been significant policy changes in that they did, in fact, adopt an ADA policy publicly. There have been other cases, though, as opposing counsel pointed out, that state that policy changes are usually not sufficient as long as the defendant in the case has the authority and the capacity to take back the policy. So, for example, in the case that they cited in their brief, Pashby versus Dahlia, that court actually found that the case was not moot. It was a case about a Medicaid policy that kept certain plaintiffs from being able to have personal and home care. And in that case, they had actually reinstated the care to every plaintiff in that case. But because they could revisit them by having more hearings, gathering more evidence, this court found that it was not appropriate to moot the case. That was also true.
Let me ask you this, though. Is it your position that because a website can always be undone and needs to be updated, that a business could never moot out a case, no matter how extensive they change their website to make it ADA compliant? Is your position that this is just not the type of remediation that can be mooted?
No, Your Honor. Plaintiffs are not taking that sort of hard line and not asking this court to adopt a bright line rule that a website can never be mooted. But
so
I will note.
Let me just jump onto Judge Livingston's question. In this case, then, what more could Secret Saturdays have done in order to make this case moot? They changed their website. They announced publicly. They have this vendor who's going to be checking the site. What more could they have done than what they've done already? What are you saying they should do in additional to make this moot?
Certainly, Your Honor. So plaintiffs have 2 points in response to that. First, as we mentioned in our brief, we don't actually think that they've remedied the harm in this case. And while that's not directly at issue in this appeal, on remand, we do plan to argue that the separate accessible website does not comply with the ADA's full and equal enjoyment guarantee. Second, in addition to that, the cases that have found that changes to a website have been mooted, as Your Honors pointed out in opposing counsel's argument, heavily are dependent on the time at which the defendant made these changes. So for example, in Diaz versus Kroger, the court very explicitly denied a bright line rule that website changes can never moot a case. But in that case, they also pointed out that nearly a year before the litigation had been filed, Kroger had already started a complete overhaul of their website. So I'm not a coder personally, but in this case, that's not what the defendants did. They waited until after the litigation had been filed, after the plaintiffs had been in contact with them about barriers on their website. They even waited until all the depositions and declarations had already been filed in this case, and then they started working on the website. And that case in Diaz, or rather another case in the Southern District of New York, said that we should actually be suspicious of defendants that take these sort of mid-litigation changes in order to take away the plaintiff's right to their day in court. And
what would an injunction look like if you're right that the case is not moot? On the current record, what would an injunction look like?
So on the current record, Your Honor, all of the accessibility barriers are still on the site, absent the stipulation, of course, that the new accessible website does comply with the WCA guidelines and holds the same information as the old website. So if we were to write an injunction for this case, after we've gone through trial and fact-finding, we would ask the court to enjoin the separate accessible website as well, because we don't believe that it complies with the ADA. So in this particular case, it's not sufficient that the defendants have created this separate website for two reasons. First is the fact that the separate website we think doesn't comply with the ADA. But the second point is that they haven't actually integrated any of the accessibility changes into their primary website. So for example, in the Kroger case, and also in the Carroll Credit Union case that came out of Virginia, in both of those cases, they had overhauled their entire website and directly integrated the accessibility changes into their primary website. So in this case, even if the separate accessible website does comply with the ADA, there's still the problem that that website is all by itself. And opposing counsel seem to take issue with the fact that it's all sort of part of one website, but this is in fact an exact copy of all the other information on the case. So it's perfectly reasonable that the harm would resume after this litigation is dismissed, in part because they don't have to do anything for the harm to resume. Their business model is such that, you know, a month from now, when they have new dinners available and new menus and new dress codes, that information will have to be created on a totally separate web page. They mentioned working it into their workflow, but it hasn't. In fact, they've doubled their workflow. This is not the same as a $30,000 ramp that took $10,000 to install and would also cost money to physically destroy and take away. This is something that if they do literally nothing, it will be obsolete in a few weeks.
So is your position simply that you cannot moot a website case unless you integrate the information into the same page that the non-disabled consumer is using? Because it's hard to see that, I mean, it's maybe a separate part of the website, but it contains all the information that is available on the website before these changes were made. And they say they will continue to. But you say that's not enough because there's a possibility they may omit these pages in the future.
Certainly, Your Honor. And we're not arguing that a separate accessible website could never be compliant with the ADA. We're not asking the court to decide this. In fact, it would be an issue of first impression in the Fourth Circuit. So that's not a question that's at issue here today. It's merely that on the issue of voluntary cessation, if a reasonable fact finder could find that the harm still remains in this case, which plaintiffs believe they could, in that case, this court should remand back to the district court for further fact-finding and briefing on this issue. And in addition to that, Your Honor, opposing counsel cited some rules by the DOJ indicating that separate accessible websites are actually compliant with the ADA. And I just wanted to point out a couple of issues with that. So first of all, those DOJ requirements are from 2010. So they actually don't follow the WCA 2.0 guidelines, which is what we are following in this case, and which is what they claim to comply with and we've stipulated to. They actually follow the WCA 1.0 guidelines, which were promulgated in 1999. The separate accessibility issue in that case had to do with phone lines that disabled people could call to get additional information, so it's not exactly on point. And they actually point in both the WCA guidelines 1.0 and 2.0, they say that separate accessible websites should only be a fallback option if they're necessary, tracking that separate benefit language in the ADA. So in this case, even though we don't actually have any sort of obligation to prove that it would not comply with the ADA at the moment, I just wanted to note that the WCA guidelines do not look favorably upon separate accessible websites. And in this case, in addition, the real problem here is that defendants haven't given us any evidence at all about the amount of work that actually went into the website. So just to compare to a couple of Supreme Court cases, in Laidlaw, there was a company that was polluting a local river. And in that case, the plant that had been doing the pollution had been totally dismantled, sold, and was completely shut down. And simply because the defendant in that case still had a permit to pollute, because they could build an entirely new plant somewhere else, the court held that that was not enough to moot the case on voluntary cessation grounds. So even though the Fourth Circuit has articulated this standard slightly differently, it's quite clear that the evidentiary burden is quite high, and we have not heard anything from defendants about how many employee hours it took to build the website, about how much money they spent. All I see is a black and white website that you can click through from on the second page.
Why isn't it significant, Ms. Hammock, that they have this subscription agreement with SiteFix that shows a commitment? They would have to breach that agreement if they were just to discontinue it. Wouldn't they be breaching an agreement? Suppose you have third-party vendor agreements for 5 years out or so. You're saying that wouldn't make a difference?
So, Your Honor, it might, but frankly, we have no information about that contract. We don't know how much the monthly subscription is. We don't know if it's a 6-month contract or a 5-year contract. That information is simply not in the record. And because defendants took on this burden, they had the obligation to put those facts in the record so that there wouldn't be disputes of these material facts. So on a summary judgment standard, they simply have not met their obligations to prove that voluntary cessation moves this case.
Are you suggesting that the ease with which a change can be made has to be reviewed on a sliding scale? In other words, the more complex, the more costly remediation is, the more likely that a matter is likely to be moot. But if it's a simple change, then no mootness, because you can go back to the old ways pretty easily.
Certainly, Your Honor, and I think the case law tracks that as well. So the comparison between the ramp, as opposing counsel said, and the sort of structural changes that can be made to websites, in this case, they haven't made the sort of structural changes that would be difficult or costly to remove. It would cost them $0, whereas dismantling a ramp would likely cost a lot of money. Your Honors, I see I'm running a little low on time, so I'm going to switch to standing so that we have enough time to discuss that.
Before you do standing there, it would cost them some money to undo these changes. The record does reflect that they affirmed that they had to strip out code and they'd have to remove certain infrastructure. Those, going back to what was there before, would cost them some money, right? Or
Your
am I
Honor, I don't believe that.
misunderstanding the record?
Your Honor, it might cost them money in the sense that if they decided to take actual active steps to remove the secondary website, that might take time to delete the code. I'm not really sure how that works, and defendant hasn't supplied us with those facts. But as far as just leaving the website up but not updating it, that would not take any additional time and money. And so it's not reasonably likely that they wouldn't just let it lapse into obsolescence if they didn't have the incentive to do so. Okay, moving on to standing, Your Honors. So all 3 plaintiffs in this case have standing because they're asking for injunctive relief. Opposing counsel is correct. They have to prove that they've suffered a past injury, and they also have to demonstrate a plausible intent to return, which is this circuit's articulation in ADA cases of what plaintiffs have to prove in order to prove a future injury.
Could you begin by addressing what injury, in fact, Ms. Gomez experienced?
Certainly, Your Honor. So in this case, Ms. Gomez has experienced a dignitary harm. And it's quite clear from the text of the ADA that it was meant to both cure physical harms, structural harms, actual obstacles to accessibility, but it didn't stop at bare accessibility. It said that people are entitled to full and equal enjoyment of goods and services. And in Tennessee versus Lane, the Supreme Court held that this covers dignitary and stigmatic harms. So opposing counsel is absolutely right that you need something more than just a value judgment that you don't like what someone is doing on their website. But in this particular case, Ms. Gomez was already a customer of Secret Saturdays when she gained actual knowledge from Mr. Ross that there were videos that weren't captioned on the website. And in this case, that is sufficient for standing. Mr. Ross also has standing in this case. Ms. Chen as well. They both are visually impaired. They both tried to use—
Ms. Gomez's impairment is what?
Ms. Gomez's impairment is stigmatic and dignitary. So she—
her
excuse me,
physical
Your Honor.
impairment.
She's hearing impaired. So when
So
she
how do
first—
the videos give her any sort of stigmatic harm?
So the videos will give her stigmatic harm if there's no closed captioning, because she doesn't know if there's anything important on the videos or not. So Mr. Stewart, the CEO, in his deposition stated that they do from time to time use videos. And the video in question from August 2017 was actually a video that included really important social information about the menu in question, including the dress code, the fact that visitors to the property needed to go around the back in order to enter the building. So this really important information, even though it's not a physical obstacle, could very easily embarrass someone who's hearing impaired and thinks they have all the information they need, but they actually can't access it. So,
but in terms of a concrete injury, in fact, in the past, you're saying that anyone who is given knowledge of an ADA deficiency on a website suffers injury just by virtue of being told, because she never watched those videos.
You're absolutely right, Your Honor. She never watched those videos. And as you pointed out, there has been some Ninth Circuit case law, which is similar. It was about a customer who was in the parking lot and was told about obstacles that were within store, that was enough for ADA purposes to be able to challenge other unencountered barriers. But also, as you pointed out, if you're not convinced that Ms. Gomez has standing, we only need one plaintiff. As the Supreme Court has made clear multiple times, the critical inquiry in standing is whether at least one plaintiff has been able to satisfy the constitutional and statutory requirements for standing.
Ms. Hammock, with respect to the other plaintiffs then, and let me ask you the question Judge Livingston asked your adversary, is the plausible intent to return have to be to the physical location or to the website? What's your position on that?
So, Your Honor, we've been arguing both. Of course, it would be wonderful for plaintiffs if this court decided that they simply had to allege a plausible intent to return to the website, because they've all done that. They've all gone to the website multiple times, even before this litigation was
Mr. Ross
filed.
and Ms. Chen never went to any dinners. So in order for them to have standing, doesn't it have to be plausible intent to return to the website? Right? That's really what, for them, it would come down to.
So, Your Honor, actually, I think that's not quite right. So they have in the past encountered accessibility barriers on the website, and that prevented them from going to dinners at that particular time. For the plausible intent to return, though, I think it's important to realize that this is functionally a laid law case. Yes, Your Honor.
I'm sorry to interrupt you, but did Ms. Chen testify that it was those barriers that prevented her from putting in a bid or purchasing a slot at one of these dinners, or was it something else?
Yes, Your Honor. She said that she did attempt to get through the website. She could not do so. And as our expert testimony has shown, for somebody using a screen reader, it would actually be impossible to fill out the form to get on the mailing list. And further, Ms. Chen and Mr. Ross both stated in conditional form that if these barriers were remedied, they would go on the website, sign up for a mailing list, and go to one of the dinners. So in laid law, this court found—
Mr. Ross, I thought he said he would consider going. He would consider going. Is that sufficient to create standing? If they fix this, I would consider going. He never gone before?
Yes, Your Honor, I think so. There are no magic words that create standing in this case. And effectively, he said the same thing as Ms. Chen, which is that if they fixed it, he would consider it. I would also like to point out a case, Equal Rights Center versus Abercrombie, where a mother was found to have standing about accessibility barriers in a Hollister store, not because she was interested in going, but because her daughter was. And in this case, Mr. Ross's granddaughter was very excited about the idea of these dinners, and he stated that he would like to take her to one. So in this case, Mr. Ross has said functionally the same thing as Ms. Chen, and also the plaintiffs in laid law, which is, if the barriers were removed, I would like to return to this place and be able to enjoy the goods and services that they offer. So I see that I have about a minute left. In sum—
Can I ask you one more question? Why would we ever make the test in this type of situation, a plausible intent to return to the website, when the website, it's not a situation where Judge Jordan described before, where you can get goods and services in on themselves off the website. The only purpose to access the website is to go to the dinner. So if you have, why wouldn't we have to have a plausible intent to go to a dinner? If they don't have plausible intent, it doesn't matter whether they have access to the website or not. Understand my question?
Yes, Your Honor. I think you're right that Secret Saturdays does offer a different business model than, for example, Target or Amazon, where you are going to want to look and check different prices and things like that, where the information is really what's most important. And I think you're absolutely right that they probably should allege a plausible intent to return to the dinners, and they have done so. They have both stated that they would. Ms. Chen in the past has visited DC 4 to 5 times per year on average. She has friends there. She works there for conferences. Mr. Ross lives in the area. In sum, all 3 plaintiffs have alleged both a past concrete personal injury and an intent to return. So I see I'm out of time, Your Honor. The plaintiffs urge you to uphold the district court's proper ruling that this case is justiciable on both standing and mootness grounds. Thank you.
Thank you very much, Ms. Hammock.
Your Honors, may it please the court. I'd like to briefly address 2 issues that were brought up by opposing counsel in this case. And the first is the issue of separate benefits and whether the website is fully integrated. While this court has not had opportunity to explicate what integrated means within the context of the ADA, the First Circuit in United States versus Hoyt's Cinema, stated that integrated means that the accessible portion must be a constituent part of the whole. And in this case, it's undisputed that the accessible page and the home page are connected to one another. They share the same root URL. And in fact, the first thing that any patron who goes to the Secret Saturdays website will encounter, whether they're sighted or use a screen reader, is a link to that accessible page. So this is markedly different from an instance where Secret Saturdays created two different websites with no way for an individual with disabilities to easily navigate between the two. And there's no requirement either in this circuit or any other circuit that there be a single web page as opposed to one web page and a specially designed web page that's keyed into accessibility issues.
Can I just ask one question about standing and Mr. Ross?
Yes.
Your adversary's argument is that Mr. Ross's statement that he would consider going to the restaurant was functionally, or to one of the dinners, was functionally equivalent to saying that he would. Do you agree with that?
No, I don't, Your Honor. If you look to pages 28 and 29 of the record, Mr. Ross was asked the question, if the website was accessible, would you intend? And instead of saying, yes, I would, of course, he stated, I would consider it. So that's markedly different from the issue in Laidlaw, which my co-counsel referenced, where the statement was, I would consider it if the harm was remedied. When Mr. Ross was asked, if the harm is remedied, would you? He still gave this conjectural, hypothetical answer that is insufficient to show a concrete, an imminent threat and insufficient to confer standing. Thank you, Your Honors.
All right, thank you, Mr. Bernstein.
Good afternoon, Your Honors, and may it please the court. Lydia Turnage, counsel for appellants on the issue of whether Title III of the ADA applies to Secret Saturdays and the Secret Saturdays website. I would like to reserve 2 minutes for rebuttal. For two reasons, this court should reverse the district court's grant of summary judgment in favor of Secret Saturdays. First, Secret Saturdays qualifies as a public accommodation under Title III of the ADA, and the fact that the company offers its goods and services to the public online rather than at a physical location does not and should not mean that Secret Saturdays can evade liability for the discriminatory configuration of its website. Second, the Secret Saturdays website satisfies the nexus test for intangible barriers of access to physical places of public accommodation. The nexus between the ability to access the Secret Saturdays website and the ability to attend Secret Saturdays events renders Secret Saturdays liable for the discriminatory configuration of its website.
So if I'm understanding your argument, your first argument is that the website itself is a place of public accommodation. Am I right about that?
That's correct, Your Honor.
Well, how can that be the case? A website isn't a place at all.
Yes, Your Honor. So both the ADA and Department of Justice regulations differentiate between a public accommodation in terms of what goods and services are being offered and a place of public accommodation, which is where those services are offered. But the use of the phrase place of public accommodation under the ADA is ambiguous, best evidenced by the fact that circuits have come to different conclusions as to just what place of public accommodation means, whether it applies to virtual spaces or only brick and mortar locations. And when the language of a statute is ambiguous, courts must look to congressional intent and the avoidance of absurd results to interpret the language appropriately. In this
case,
case,
to Webster's dictionary that says place is a physical environment or physical surrounding. So why doesn't the plain meaning, according to a dictionary, control? Why isn't that unambiguous?
Your Honor, the definition of place of public accommodation under DOJ regulations is a facility operated by a public accommodation. And the definition of facility further includes not just real property, such as buildings and physical sites, but also personal property and equipment, which are not generally considered places in the plain meaning of the term. The Department of Justice itself has also interpreted the phrase place of public accommodation to apply to virtual spaces.
What's the relevance of the regulation? Are you saying we owe Chevron deference to this regulation and interpreting the statute? I'm a little confused.
Your Honor. No, Your Honor. Neither our deference nor Chevron deference apply in this case because the Department of Justice has not explicitly and officially either reinterpreted its own regulation or established new regulations to align with its interpretation of Title III. All plaintiffs are asking is that the court apply Skidmore deference to this case on the basis of the department's unofficial interpretation of Title III under the traditional factors of the validity and thoroughness of its reasoning and the consistency of its pronouncements as to the proper interpretation of Title III over time.
And we get to that only if we determine that the statute is ambiguous, as you began with, correct?
Yes, Your Honor. This court
is the statute, let me return to that question then. My colleague has asked about the dictionary. Section 121817 also lists a variety of physical structures in defining the public accommodations which are subject to the ADA. You said that there must be an ambiguity here because there's a circuit split, but I'm not sure that a circuit split alone is a reason to conclude that a statute is ambiguous. So help me out.
Certainly, Your Honor. I would first point out that Section 12181 refers not just to places, but also to the services of public accommodations. And secondly, that section of the ADA refers not just to the goods and services offered at or in a public accommodation, or a place of public accommodation, but also the goods and services of a public accommodation. So placing such a heavy reliance on the dictionary definition of the word place in construing what kinds of goods and services are covered by the ADA is at odds both with the other language included in the section, as well as the underlying purpose of the ADA, which is to provide which is to provide access to the goods and services themselves, and not simply access to the facilities where those goods and services may be offered.
But you don't think that the listing of different types of public accommodations in subsection 7 of section 12181 is exclusive?
No, Your Honor. That list is intended to be illustrative, not exhaustive, as Congress explicitly pointed out when it stated that plaintiffs bringing ADA claims do not have to show that businesses are similar to those listed in the statute, just that they fall within the same general categories. Here, Secret Saturdays...
If that's the case, give me a definition of public accommodation.
Well, Your Honor, as I previously stated, a public accommodation is simply a private entity that provides goods and services to the public. A place of public accommodation is defined separately under the statute. Secret Saturdays is a public accommodation because it offers sales and services to the public and profits from those sales and services. Whether or not it operates a place of public accommodation depends on whether this court reads that phrase to include virtual spaces. But certainly the Secret Saturdays business model fits within the categories listed in section 12181.
But if you're right, that list is completely superfluous. It's unnecessary.
In what sense, Your Honor?
No need to list all of these public accommodations in such detail if all a public accommodation is a private entity that offers goods and services. That's an all-encompassing definition.
Yes, Your Honor. I would go back to, sorry, pardon me.
It applies to almost everything in society.
Well, Your Honor, I would point to the fact that the purpose of the ADA, as explicitly stated in section 12101, is to provide access for individuals with disabilities to all aspects of American social and economic life. So it certainly does not run contrary to the language of the statute to say that the categories of public accommodations should be read as broadly as possible.
Does it matter that computer technology was certainly not what it is today back then when Congress passed the ADA?
No, Your Honor. The fact that the internet did not exist at the time that the ADA was passed does not mean that this court reading the phrase place of public accommodations to include virtual spaces would be a form of judicial overreach. Courts regularly apply existing language to new contexts. And in a separate ADA case, Pennsylvania Department of Corrections versus Yeski, the Supreme Court explicitly stated that the ability to apply the ADA in contexts not contemplated by the statute itself is a function of its intended breadth.
Why wouldn't Congress, when they amended the ADA just a few years ago, have made clear that they wanted the ADA to apply this new technology? As Judge Jordan pointed out, they clearly, when they wrote the statute, weren't thinking about the internet or websites. So why wouldn't they have made that clear just a few years ago?
Your Honor, the purpose of the 2008 amendments was extremely limited. Those amendments were simply enacted to rebroaden the definition of the term disability under the ADA following Supreme Court decisions and EEOC regulations that gave a narrow construction to the term. These amendments were not intended to be a complete review of the entirety of the ADA, so the court should not put too much weight on Congress's silence as to the appropriate scope of Title III in this case.
Your adversary also points to the 21st Century Communications and Video Accessibility Act and the fact that it specifically excludes internet content. What's the relevance?
Your Honor.
How should we take that?
Your Honor, opposing counsel's reliance on the 21st Century Communications Act is misplaced. That act amends the Federal Communications Act, not the ADA, and it applies not to public accommodations, but to communications carriers, such as telephone, radio, and internet service providers. That act is intended to regulate the availability of the kinds of technical accommodations that make websites accessible. However, the responsibility to implement those accommodations are still left up to public accommodations themselves. And the carve-out that opposing counsel refers to in terms of the internet services, apps, and I forget the term verbatim, but that carve-out is simply a recognition that it is not the communications carriers themselves that are responsible for ensuring that websites are accessible, simply that they make such accessibility possible.
Can I ask about the nature of the circuit split in this case? Your adversary says that really your position comes down to the Fourth Circuit's decision alone, and that the references to the Second and the Seventh overstate the significance of those cases. The Second Circuit case does seem to be talking about stating that Title III doesn't ensure that only physical access to places of public accommodation is covered by the Act, but I think it may be overreading it a little bit to say that it said that Title III would apply to something like a website. So what am I missing in the other cases on which you rely?
Your Honor, I would point out the fact that in addition to the Second Circuit, both the First and the Seventh Circuit have found that the ADA can apply to virtual spaces. And importantly, both the First and the Seventh Circuits have explicitly stated that the ADA applies to virtual spaces in themselves and not just in relation to their connection to physical places. I would also point out that opposing counsel says that the First Circuit precedent in the car parts case does not apply here because it was a case decided in the context of discriminatory insurance policies. But the three circuit court precedents that opposing counsel relies on in his brief, the Ninth Circuit, the Third Circuit, and the 11th and the Sixth Circuit's decisions were all also decided in the context of discriminatory insurance policies. These cases were decided over 20 years ago, not in the context of web-based services, and not at a time when the internet has took on the central role that it plays today in American social and economic life.
What about the Noah case, though? I know it's an unpublished decision of our court, but that was an AOL chat room. You just think that was wrongly decided? That's the reasoning of that is not distinguishable from your argument here, right?
Your Honor, the reasoning in that case is distinguishable. And it's also, that decision is not controlling in this case because it was decided under Title II of the Civil Rights Act and not Title III of the ADA. It's important to point out that Title II...
It was the same term they were looking at, though. Wasn't it the same term?
Both statutes do employ the phrase place of public accommodation, but that phrase is defined in a significantly different way under Title II of the Civil Rights Act. In every example of a place of public accommodation listed under Title II, you see the word place, facility, physical location, and other words that indicate a much higher requirement that a place of public accommodation be a physical place. That language is conspicuously missing from the language of Title III of the ADA. And Congress explicitly stated as well at the time that the ADA was passed that it was important and in fact necessary to interpret the scope of Title III more broadly than Title II of the Civil Rights Act, because discrimination against individuals with disabilities is not limited to certain types of accommodations. So in this case, the Noah decision is not persuasive.
If we agree with you, we have to write an opinion that provides some guidance to the lower courts about what fits and what doesn't fit within the statute. So in your view, what virtual space would not qualify as a place of public accommodation?
Your Honor, regardless of whether this court applies the phrase place of public accommodation to virtual spaces in addition to brick and mortar locations, they still must meet the requirements under Title III that they provide commercial goods and services to members of the general public. So websites like personal blogs or social media accounts would not fall under the scope of the ADA because they're not providing the kinds of goods and services that Secret Saturdays is providing in this case. So regardless of where is considered a place of public accommodation, what kinds of services are being offered and to whom they're being offered is still an important consideration for whether or not a website would be subject to ADA liability.
But any commercial entity would fall within your definition then?
A commercial entity that's offering goods and services to the public, yes.
There's almost no commercial entity that doesn't do that. It has to offer something to earn money and survive as an ongoing concern, right? So every commercial entity, almost by definition, would qualify as a place of public accommodation under your theory.
That's true, Your Honor, but it's important to note as well that ADA liability turns on a reasonableness standard. So for smaller entities or independent operators that may not have the same resources as Secret Saturdays to impose higher standards of accessibility, they're not going to be held to the same standard of compliance because the ADA makes specific recognition of the fact that holding businesses to a higher standard may impose undue burdens. So even if a greater number of commercial entities would be covered in this case, if websites are subjected to ADA liability, that reasonableness standard is still going to protect smaller entities that may not have the resources or infrastructure to provide the kind of accommodations that Secret Saturdays is able to do in this case.
Turnage, let me ask you about the second issue. If we disagree with you, we think the website has to have a nexus to a physical location. It's your position that a person's home becomes a place of public accommodation by virtue of these dinners, correct?
Yes, Your Honor.
So your adversary points out in their brief about book clubs, a home wedding. I would put into that category, maybe dating myself a little bit, but there used to be things like Mary Kay Cosmetics and Tupperware parties where people would gather in their home and it'd be for profit. They would make money. So all of those events, do you have to have a ramp in your home then if you're going to have one of those types of parties or weddings? Is that what your position would lead to?
No, Your Honor. I'll reiterate the point that I just made that regardless of where goods and services are being offered, you still have to meet the requirements that what is being offered is for commercial purposes to the general public. So that would rule out the first two examples that you gave about book clubs and weddings, which are not providing commercial goods and services. What
about my example about cosmetics or one of those things where you invite people in your home and you get a commission on what they buy in your home?
Yes, Your Honor. In that case, it is possible that such an activity could be considered commercial. It might depend on whether or not you are making that kind of event open to the general public as opposed to a close circle of friends and family, because that would also be a consideration under Title III. But again, even if that were to fall under a broad reading of Title III, reasonableness standards would prevent something like the example you gave where suddenly people would have to provide wheelchair ramps in their homes for small gatherings, especially if those gatherings are intended only to bring in friends and families to the home and not the general public, as is the case with Secret Saturdays events.
Well, what about your adversary's argument that the rest of this statute's language, you have to operate the place of public accommodation? And their position is that this is really, the facts here are more similar to hotels.com. This is not a case where they're doing much more than being a booking agency. And so they aren't operating the home, even if we look to the home as establishing the physical structure and look to the nexus there.
Just very quickly, I see my time is running out. If I may just answer your question fully. In this case is distinguishable from the hotels.com case because the day-to-day managerial control that was used by this court as a standard in that case is not applicable in the context of the ADA. What's important under the ADA is whether a public accommodation exercises control over the accessibility of its venues, which in this case, Secret Saturdays does, because it has taken it upon itself to ensure that its facilities are physically accessible to guests of its dinners. And secondly, Secret Saturdays does not act purely as a platform for connecting third parties. It's invested in both the organization and the execution of its events. I mean, this is a company that employs event directors, marketing directors, as well as its own chef. And it holds itself out as the host of these events to the public. The Secret Saturdays website says, "Come join us." It does not say, "Come join them." And it's disingenuous for opposing counsel to claim that it has no involvement beyond acting as a conduit for these third parties. And with that, I will return on rebuttal. Thank you.
Thank you very much, Ms. Turnage.
Thank you.
Your Honors, and may it please the court, my name is Andrew Canarion, and I'm here on behalf of Secret Saturdays. The term place of public accommodation isn't just a placeholder in the ADA. In both parts of the statutory provision that we're talking about today, it does real work. An easy way for this court to understand the important work that the term place of public accommodation does in both parts of the statute is that it's essentially answering the where question and the who question. Where does the ADA apply? It applies in the services of a place of public accommodation. Who does it hold responsible? Only the owners, lessors, and operators of places of public accommodation. And
is the listing of entities in subsection 7 of section 12181 exclusive?
It is not exclusive, Your Honor, but as opposing counsel said, it's illustrative of the type of places that the ADA is meant to cover, and all 52 specific examples are physical places. And when we have a defined term providing 52 examples of the type of what's considered a public accommodation, that's a very strong indicator here that the term unambiguously is referring only to physical places.
Well, let me give you a couple of examples that over time have sort of turned from brick and mortar places to, at least in part, virtual places. For example, an elementary, secondary, undergraduate, or postgraduate private school or other place of education. In the state of Florida, for example, there are completely online elementary and high schools for students who may wish to avail themselves of those services. There may also be adoption agencies which are completely virtual and provide services that don't require physical contact. People who for a fee may put together prospective parents with prospective children, adoptees, and then let everything else go forward through other third parties. So I'm not sure that the listing of those sorts of entities in subsection 7 necessarily means a brick and mortar place.
Well, the entities that Congress put in the definition, at least at the time, we're all referring to physical places, and it's really the virtual definition that runs into a problem with the text. You know, when we have physical places like a laundromat or a lawyer's office, defining place of public accommodation as a website, defining the place of a lawyer's office or a laundromat to be a website, that's really the definition that's straining the text. To go to the specific examples that you brought up of virtual schools, there would need to be, under the ADA, a physical place of public accommodation. That's the requirement that Congress put into the statute, and they haven't changed. And
your position then is that a purely internet company can be completely inaccessible to a deaf person or to a blind person, and they would have no recourse at all under the ADA. Isn't that your position?
Our purely
internet-based company.
Our position, Your Honor, is that a solely web-based company is not covered by the ADA because Congress didn't include those.
So you at least concede then that that's completely inconsistent with the purpose of the ADA. They point out that in the findings of the ADA, the purpose was to allow disabled people to fully participate in all aspects of society. And you know how many purely internet companies there are at this point, Amazon being the leading one. So Amazon could be completely inaccessible to disabled people, and they would have no recourse. Is that, am I misunderstanding your position?
Our position is that if there is a physical place of public accommodation, the ADA would apply, but if it's only a virtual place, then the ADA would not apply. That's the way Congress structured the act. That's the way Congress defined public accommodation. We have to give.
But doesn't my colleague point out to, it's almost an absurd conclusion, isn't it? That the ADA would not apply to Amazon because it does not open any facility to the public in any way, but would apply to Target when they are both doing essentially the same thing, selling goods over the internet, but Target also happens to have some brick and mortar stores.
Well, to answer your hypothetical directly, my understanding is that Amazon does own, for example, Whole Foods, so some of their services are in a brick and mortar.
That's recent.
Right, I understand, Your Honor. But this is consistent with the Ninth Circuit that has dealt with this issue. They've agreed that a standalone website is not covered by the ADA, and the DOJ agrees with this position as well. The DOJ defines a place of public accommodation as a facility. So it's not just the majority of the circuit courts and the reasoning of this court in the AOL decision that this court has to rely upon. It's the DOJ as well that is agreeing with our position that there needs to be a physical place. I would also like to note
let me go back, if I could, let me go back to the question I asked and then I'll leave off. Is it your position that today a purely internet private school for profit would or would not be covered by the ADA?
It would not be, Your Honor, if there's no physical place of that school. Despite
the fact that the plain text would seem to cover it, right?
Well, it comes down to...
It's a private school. It does that subsection J, doesn't say anything about a physical plant.
Well, let me answer your question in two ways. There would be a physicality requirement brought in with the word place. Let's not forget that the word place of public accommodation is doing some work there. But even if we were to look at the different categories and specifically the category at issue here, it's an even more compelling case that in the food and beverage category that there's a physicality requirement, because for the food and beverage category, they're very clear that they're using the word restaurant and bar or other establishment. So even if there is an argument to be made in the school context, the food category, which is at issue here, the restaurant and bar category, it's much clearer that we're talking about a physical place. I would add that the Supreme Court reads the ADA comparably to the Civil Rights Act, and as opposing counsel mentioned, the Civil Rights Act is very clear about the physicality requirement in the definition of place of public accommodation. In the PGA Tour decision, for example, the Supreme Court was looking to the Civil Rights Act for guidance on how to interpret the ADA. That only bolsters the fact that there's a physicality requirement in the definition.
In their brief, they point out that although obviously the regulations focus on brick and mortar type locations, they reference the fact that travel services is contained within the regulations as well, and that creates some ambiguity that it goes beyond a physical location. Do you want to address that?
Well, travel service as used in this context is talking about something like a travel agency.
They didn't say travel agency, though. They used the word services, so that seems to extend it to an inter-based travel service, right?
Well, I think we need to understand the word travel service in the broader context of the statute. Let's not forget that there's another section devoted to transportation services writ large. Section 12184 deals with transportation services. It would be odd if Congress devoted transportation services their own section and was also talking about transportation services here. I think when read in the broader context of the statute, they're more likely talking about travel service as just another example of a service establishment. They give examples like a beauty parlor or a laundromat. A travel service is something like an office that's providing travel agency services in this context. Now, I also want to turn to...
Could I ask you one more question to follow up on that? in today's virus quarantine world, where would you place entities like Uber Eats and Grubhub?
Well, those may be covered by the ADA if there's a sufficient nexus to a physical place of public accommodation. So, for example, if
but it's not their place of public accommodation. They don't own the third-party establishments that you're buying food from. All they're doing is providing the service of delivering the food to you, and they're operating basically completely on the web.
Well, I think it would turn to the facts of the specific example. There are some supermarkets that operate a delivery service. So in that situation, if there was a sufficient operational control, there would be. I think on specifically the example of an Uber Eats, it would come down to a factual question of whether or not the place that's giving the food in the first place is exercising a degree of operational control. And there would need to be some factual development on that issue. I would like to just, turn quickly to, again, the regulations here, because I think opposing counsel confuses the point a little bit. The DOJ has a regulation that defines a place of public accommodation, and opposing counsel agrees that the DOJ should be given substantial deference in how the term place of public accommodation is being defined. They defined a place of public accommodation as a facility, and then they defined a facility as any or all portion of buildings, structure, sites, complexes, equipment, rolling stock, etc. They're talking about only physical things. So even if this court were to find that the statutory language were a little ambiguous and wanted to look to the DOJ regulations for guidance, the DOJ offers a clear definition, and this court need not look beyond what the DOJ provides in their unambiguous regulation.
If we find it's ambiguous, why shouldn't we also look at the legislative history? Wouldn't we look at that as well?
Well, I think it would then be a more totality of the analysis, looking at legislative history, looking at the DOJ regulations. I think that
well, on the legislative history, they point to a committee report where it's written in the report: the committee intends that the types of accommodation and services provided to individuals with disabilities under all titles of this bill should keep pace with the rapidly changing technology of the times. So isn't that a clear intent that they understood that the definitions might have to be adapted to changing technology, which is exactly what we have here?
Well, the ADA has adapted to some degree with technology. So for example, the web services of a physical place of public accommodation are covered by the ADA. That's a perfect example of how the statute has evolved. But there are key structural and definitional aspects of this statute that one statement of legislative history can't simply gloss over. When Congress is providing a very comprehensive definition and also putting the word place before that, you know, Congress is making clear that there needs to be some tie to a physical place of public accommodation. And finally, I would just add that if this court wanted to know where Congress's thinking was right now on the issue of website accessibility, you know, it can look at the legislation that's happened after the fact. So, for example, the ADA has been amended on at least one occasion in 2008 amendments, and they didn't touch the website issue, even though the DOJ and many circuit courts were interpreting the ADA not to apply.
Just taking us back to the regulation for a moment, you referred to facility and listed the first 4 or 5 definitions of facility, but doesn't it end with private property? How does that constitute a personal property? I don't have the language of the regulation in front of me. Doesn't that create some problems for your argument?
Well, I think the 6 words you're referring to is or other real or personal property. So I think we would look at that terminology in the context of the regulation. And I think when you have a residual phrase like that, other real or personal property, they're talking about personal property of a similar nature to the specific examples being provided in the definition of a facility.
So you mean like a food truck? Is that what you're talking about?
If a food truck may count as a facility, if there is significant operational control, if they can meet that operation test, But just to hammer that point home on the definition of facility, under the Supreme Court's decision in Kaiser v. Wilkie, a regulation doesn't become ambiguous simply because there's some undefined term. Courts do use the normal means of statutory interpretation when looking at a regulation to resolve any ambiguity before going beyond that regulation. So here, when we have the phrase "or other real or personal property," following specific examples of only tangible, real, or physical property, like any other statute, this court would apply personal property in the same way as those preceding specific definitions. Now, with my remaining amount of my time, I want to turn quickly to the home argument. Just to be clear, plaintiffs offer no case for the proposition that a home itself can be a place of public accommodation. In fact, the case law says otherwise. Homes are not covered by the ADA. And moreover, even if this court, for the first time, were to find that a home to be a place of public accommodation, Secret Saturdays doesn't have the day-to-day managerial control over that place of public accommodation to make them liable. Secret Saturdays is merely a service provider operating in a very limited capacity. Their services are limited to matching potential chefs and homeowners and providing ticketing.
I don't really understand that part of the record. I mean, your client is not really a booking agency, is it? I mean, Stewart describes he's an entrepreneur in the restaurant industry. You don't take all comers. You carefully pick and choose the chefs and the homes to create culinary experiences. That sounds to me more than just a ticketing agency or a booking facility.
Well, so as I said, Secret Saturdays plays two functions. They are matching the chefs and the homeowners, and in addition to that matching service, are providing the ticketing services. But Mr. Stewart's unrebutted testimony is that it's the homeowners and the chefs who are making all of the arrangements about catering, the servers, the music, the decoration. That's unrebutted testimony from Mr. Stewart describing the relationship between the chefs, homeowners, and Secret Saturdays. Secret Saturdays is merely providing one service to the homeowners and the chefs. And the mere existence that there is a contractual relationship between the parties doesn't necessarily mean that Secret Saturdays is running the show. I mean, all service providers are going to have some contractual relationship. What's key is to look at Mr. Stewart's testimony, which again is unrebutted, describing the extensive control that the homeowners and the chefs are having here.
Is it significant?
What's the division of? No, I'm sorry, Judge Bianco. Go ahead.
Is it significant that Stewart admitted that he considers accessibility needs, and your adversary says under the Neff case that is significant? He's operating the home by stating he's assuming responsibility to some extent, at least, to make sure it's ADA compliant.
Let me answer that question in two ways. First, just on the Neff case, that was a Fifth Circuit decision saying that a franchisor was not an operator of a place of public accommodation. I just want to make that point clear. But going to Mr. Stewart's testimony, Mr. Stewart testified that as long as a home can accommodate 6 individuals and has some historical value, he's willing to do business. So Mr. Stewart is not selecting these homes based upon their accessibility needs. He actually has a pretty low bar as to who he wants to do business with. And that's consistent with his understanding that it's really the homeowners and the chefs who are responsible here. And I think that makes some overarching a point here. If it's a court were to hold for the first time that a home were a place of public accommodation, it's not as if someone won't be held liable. If this court were to find a home to be a place of public accommodation, the homeowner is definitely in, and potentially the chef. The question is, did the plaintiffs, sue the right party in that situation? And for Secret Saturdays to also be liable, they would need to be exerting that kind of day-to-day managerial control like an owner would be, and they fall far short of that. They're providing a minimal degree of services to the homeowners and the chefs.
What does the record say about the amount of money that is charged to individuals who want to come to these dinners, and how that money is split among Secret Saturdays, the homeowner, and the chef?
The only reference to profits is that Secret Saturdays retains the bulk of the profits from the ticket sales. There's nothing in the record about pricing or any of those decisions. What it is in the record, though, is that it's undisputed that it's the homeowners who are procuring the services of the servers, to musicians, or the decorations. Secret Saturdays doesn't even have any employees on site to do any operation.
If I can ask you one more question, then what are the homeowners and the chef getting out of this if Secret Saturdays is keeping the bulk of the reservation money?
Well, presumably the homeowners and the chefs are getting some money from the enterprise. There's some sort of split that's not described in the record. If I could just conclude, I see my time has expired. If I could just quickly conclude, the term place of public accommodation needs to be a physical place, and the analysis starts with a physical place. If the plaintiffs want the ADA to be written differently and have it applied to physical place of public accommodation, they need to be making that argument on Capitol Hill, not in a court of law.
All right, thank you very much.
Your Honors, I'd like to address 2 points on rebuttal. Firstly, opposing counsel's reference to the DOJ regulations defining a place of public accommodation as a facility. That definition includes all or any real or personal property or equipment. Neither personal property nor equipment necessarily mean places, and both personal property and equipment are required in the maintenance of websites in the form of host computers and data servers, which the Supreme Court explicitly recognized in Reno versus ACLU when it characterized the internet and internet communications in part based on its relationship to physical property, such as data servers and host computers. So the DOJ's reading of Title III as applying to websites is not in direct conflict with its own regulations. And again, Auer and the Kaiser case don't apply in this situation because the DOJ is not explicitly revisiting its own regulations. Secondly, opposing counsel's point that Secret Saturdays does not maintain the requisite level of control over its venues is incorrect. The day-to-day managerial control standard does not apply in ADA cases. Courts look to whether or not public accommodations exercise sufficient control over accessibility. And as the record establishes, Mr. Stewart takes at least some responsibility for the accessibility of his venues. He asks about physical accessibility needs in the sign-up form. He says that one of the reasons why he asks about that is so that he could provide wheelchair ramps potentially, which aren't going to come from the homes or the homeowners themselves. So there's at least enough on the record for an inference in favor of the plaintiffs in this case, as is appropriate on a motion for summary judgment, to find that Secret Saturdays does exercise operational control over its venues. And I see my time has expired, so thank you very much.
Thank you very much. Okay.
Court is adjourned.
Hear ye, hear ye. The court is back in session.
Welcome back, and thank you very much for the arguments that you presented. The three of us were very, very impressed, and I'm sure I'm not speaking out of turn when I say that we wish we had advocates who were so well prepared all the time in our own oral argument sessions. So congratulations to all of you for getting to this point, through which I'm sure was a very difficult competition, and for giving us the benefit of your arguments. So we're going to go around and give you some brief comments, and after that we'll go ahead and announce some of the competition winners. So with that, Judge Livingston or Judge Bianco, if you want to start.
I'll start. Yeah, really wonderful. It was a a pleasure to listen to the four of you argue. I have said this once or twice before, but I don't always say it after a moot court. One of the things I didn't like when I became a judge, as opposed to being a full-time professor, is that when you work on advocacy as a full-time professor, when you see really great arguments, you know, you listen to the student, you think, boy, this is great, wonderful. Oh, they're nailing every question. At the end, you get to go, high five. So when that happens in court, you know, you can't do that. So I sometimes do see a great argument in court that makes me want to do that enthusiastic response. I can't anymore. The arguments today really did. You were answering questions. You put thought and care into how to present your arguments, and in very strange circumstances. I have to mention that. I mean, I expect in practice, as this competition was going on, you were thinking about how to make eye contact and how to nod your head thoughtfully and how long a pause should be. And this new environment has altered all the rules for that. And lawyers and judges around the country, Judge Bianco and I, and I'm sure Judge Jordan as well, we've been doing telephonic arguments, and we don't have the virtue of this video. It seems to me a bit nicer with the video, but still, it's not like a in-person argument. So lawyers around the country are feeling their way, and you had the experience of being part of that. That's very historic. The only other substantive thing I'll say is that for the people who are watching, what was very evident in the prep that these four people did, they were leading the conversation, and in effective oral advocacy, the real art of it is answering the question, being respectful of the court, always answering, you know, the court feels its questions and its concerns are being addressed, but you show up with some points you wanted to make. And the trick is being able to pivot from a question respectfully to return to points that you still hadn't gotten to and wanted to make. So in the really great arguments, in a very subtle and fluid way, it's the oralist who's managing to make sure that the gist of their argument is made and it comes forward, no matter what questions are flung by the judges. And that's what all four of you were doing. You were choreographing your performance, and that's takes a lot of practice, and you were well on the road to being really great lawyers. Congratulations.
I just wanted to, before I get to the comments, I just wanted to quickly just state what a privilege I consider it to be invited by the school to judge. You know, there's no bigger fan of Columbia law than me. I know that was the whole foundation for my career, and I could never repay the school for giving me that opportunity. I will say this is surreal for me in particular, because I don't remember if it was 1990 or 91, because I don't remember if I was a 2L or 3L. I think I was a 2L, so it was 1990, so it'd be 30 years ago right now. I was in this finals. And the reason I entered this competition was because I was terrified of public speaking in law school. I decided that was a big problem for a lawyer. And so I wanted to be an AUSA. I was like, I got to do the stone competition to get used to this. And then to my utter shock, I made it to the finals with, at the time, you know, DC Circuit Judge Ruth Bader Ginsburg presiding. And all I kept thinking, with Judge Karras, my good friend, is my adversary. And I kept thinking, I'm way over my head right now. I'm not ready for this. But I will say, all four of you were so much better than I ever was in that competition. It was really an amazing thing for me to watch. And I've done a lot of competitions. My first one at Columbia, I think this is the best one I've ever, and I'm just saying that, this is the best one. I was, the other judges, and I was throwing you every fastball that I had. I was not holding any questions back. I was really, you know, I assumed you would have the mastery of the facts and the law, because I just knew that would be the case. But what we were all doing was testing where you would draw the line. Would you go too far? You know, those were really tough questions about line drawing, about, you know, the statutory language, and you all hit them out of the park. You know, there was none of these awkward pauses. The answers were sharp. They were very responsive. They were organized. You incorporated things that you heard us ask your adversary, things that they said. And it's a work of, I'm just echoing what Judge Livingston said, it's really like a work of art when you see a lawyer, in this case, law students, practicing advocacy at that high level. So you were all awesome. You have bright, bright futures ahead of you, and your school and your family should all be very proud of you.
Well, I'm the one without connections to Columbia, but Judge, like Judge Livingston and Judge Bianco, I'm privileged to have been asked to participate in this process and the competition, and it was an honor to hear you guys argue. To echo what my colleague said, one of the many difficult things that judges do is just not try to figure out answers, but how to get to answers and how to write opinions that provide guidance and also don't get judges and courts in trouble in the future in other cases that keep coming up. And that's why you get all of these, what you think are harebrained questions from the bench all the time. And the good lawyers, even when they think that judges are out in left field or not paying much attention, do their best to answer the question and then pivot, as all of you did very well, to what you want to present and what you want to explain. And all of you did that very, very well. You were all answering questions. I can't remember a single question that any one of you tried to dodge. And that is the hallmark of a very, very good oral advocate. There are very few things that get appellate judges and district judges, for that matter, more upset than lawyers not answering questions. And I think all of you did really, really well. And for the audience, for those who are watching this on the webinar, these were really hard issues. I teach federal courts at Miami, and justiciability is hard in every way, shape, or form. Standing, mootness, political question, ripeness, all of those are usually much more difficult than merits issues sometimes. And you guys, those of you who are handling those issues, Ms. Hammock and Mr. Bernstein did a really good job on them. And on the statutory side, this was a really complicated problem. I don't think I've seen a law school moot court problem more complicated than this one. The statutory analysis was hard. The regulatory side of it was hard. The legislative history, the equity side, to the extent you get at it, is hard. And Ms. Turnage and Mr. Canarian did a really, really good job of understanding all of that and being able to move from one issue to the other without any problem whatsoever. And that's a credit to all of you. So again, thank you very much for inviting the three of us to do this. We really, really appreciate it, and we're glad we were able to participate with you. I think that leaves the awards, right? Okay, so the award for Best Brief was not one that we were in charge of taking care of, but we've been told by the law school, the person who won the Best Brief award, our job was to figure out in a very, very difficult discussion who the best oralist was. So without further ado, both the Best Brief and the Best Oralist awards go to Ms. Hammock. So congratulations.
Thank you so much. Oh, thank you.
Okay. I don't know.
I don't know if I'm supposed to say anything else. Emily, what am I supposed to do?
I think you're good.
Okay. Thank you. Thank you.
Congratulations.
So thank you, Emily, for working so hard. Emily and Eileen both for working so hard to make sure that we could still do this even in these very weird times.
Yeah, thank you again to all of you. You were great, and to the law school and all of the people who helped put this together and get us technologically up to speed. We really, really do appreciate it. And we hope to see you guys in a non-virtual world soon.
Thank you so much to all of the judges.
Okay.
Congratulations to all of you.
Court is dismissed.
Okay.